Under the executive budget adopted in 2014, New York made major changes to its estate tax laws. I'd like to highlight 3 areas: the increased exclusion amount, the gift add-back, and portability. The New York exclusion amount was increased from $1 million to just over $2 million for persons dying as of April 1, 2014, and is currently just over $3 million for persons dying as of April 1, 2015. The New York exclusion amount is scheduled to increase gradually, and beginning January 1, 2019, the New York exclusion amount will be indexed for inflation and will match the federal exclusion amount. However, there is a catch to the increased exclusion. If the taxable estate exceeds 105% of the basic exclusion amount, the benefit of the exclusion is lost entirely. This means that the entire estate is subject to New York estate tax. This effect is referred to as the cliff. A simple method to avoid the cliff might be to make a charitable bequest under a will in the amount needed to reduce the taxable estate below the exclusion amount. Another significant change in the New York estate tax law is that gifts made by New York residents within 3 years of death between April 1, 2014 and January 1, 2019 will be added back into the New York taxable estate. The effect is to increase the size of the New York taxable estate by the amount of any such gifts. The following are not added back as taxable gifts for New York estate tax purposes: gifts within the federal gift tax annual exclusion, gifts of real property located outside of New York, and tangible personal property located outside of New York. This change means that New York residents will have to rethink lifetime gifts or even deathbed gifts, which have been a common technique since the state does not have a gift tax. You also may have heard that the federal estate tax now includes a portability feature. This increases the credit allowed to an individual's estate by the unused exclusion amount of that individual's last deceased spouse. In other words, a surviving spouse can potentially shelter twice the federal exclusion amount from federal estate taxes. New York estate tax law does not allow for portability of the New York exclusion amount. The exemption is either used at the first death or lost. Many couples whose combined estates are less than double the federal exemption amount have simplified or plan to simplify their estate plans by taking advantage of exemption portability provisions of the federal estate tax. Following a simplified federal plan in New York may not be the best plan. Because New York does not have a portability rule, a credit shelter trust is still recommended for estates of couples that may be subject to New York estate tax. For New York residents with assets in excess of the New York exclusion limits, their wills and trusts should be reviewed and revised to assure the estate plans are appropriate given the current estate tax laws. Further, gifts over the annual exclusion amounts will require careful planning in light of the new add-back on taxable gifts. Most importantly, planning will be essential for New York estates to avoid the cliff and fully utilize the New York exclusion. Finally, always remember that strategies that may be appropriate for one person may not be suitable for another person and should be discussed with your attorney or tax advisor.